Hey Zach, it's so good to get to talk to you about your practice. I wonder if you can tell us what's new in your world.
Sure, yeah. Thanks for having me here, Jordan. Something new that's recently occurred is a new AI law in Colorado that is a very complicated law that hopefully we can try to unpack a little bit.
Okay, wow, a new AI law in Colorado. Well, tell us a little bit about that. What do business owners need to know?
Sure. So Colorado's one of only a few states now that is regulating the use of AI, and at the risk of oversimplifying here, this particular law applies to the use of technology called Covered ADMT.
Okay, covered ADMT. What's that? Tell us what that is.
So Covered ADMT. ADMT stands for Automated Decision Making Technology.
Okay.
Covered means it's the type of ADMT that the law regulates rather than uncovered or plain ADMT that is largely unregulated by the new law.
Okay. So what does this covered ADMT require? What do I need to do if I use that in my business?
Sure. So if you are using covered ADMT, that means a couple things. Number one, you're using that technology to make a decision about a person in a covered domain.
Okay.
The law calls a covered domain, meaning different industries, residential real estate being one of them.
Okay. Can you give us some examples of, in the residential real estate domain, when someone might be using covered ADMT?
Yeah, so if someone's using covered ADMT in a residential real estate setting, it's a scenario where they are making a decision based on personal information that's put into the technology concerning that individual. And in the real world, that might be something like, let's say, a real estate broker is representing a seller of residential real estate, and the seller receives 3 offers to sell the property. And they're all really, really close in terms, both financial and legal and timing, and the broker isn't quite sure which one they'd recommend that the seller sign to go under contract. And so they kind of set out pros and cons of each, and then they input some personal information about the seller and those kind of pros and cons lists about each offer into covered ADMT, and it creates an output that says, well, you should rank the offers 1, 2, and 3, and broker and seller go along with that recommendation, and whether or not the recommendation is successful, that's the situation of a listing agent using covered ADMT.
Okay, well, thank you. So just to be clear, if I am that listing agent and I'm using AI to help me make a decision or make a recommendation to my seller, what type of disclosures do I need to provide to my seller about the fact that I'm using AI?
Yeah. So really, once you find yourself in that world as a listing agent, the user, or the statute refers to as a deployer of covered ADMT, then in that situation, first and foremost, there must be an upfront disclosure. In this case, certainly to the seller, in our example, perhaps also to each prospective buyer who submitted an offer.
Okay.
It's a pretty generic disclosure that explains in plain language what technology is being used, where you can get more information, those sorts of things. That'd be the first step.
Okay. And what's my next step? What do I need to be aware of using that AI product for that seller?
Right. And so then The next kind of tier of disclosure is something that occurs when an adverse outcome is generated. In other words, if in our hypothetical, the way that those offers are ranked doesn't result in a contract at all, one might argue that that's an adverse outcome for the seller, and therefore it triggers a heightened disclosure obligation for the listing broker to the seller, which would require a more personally tailored disclosure. Hey, here's what happens, here's why it was an adverse outcome. You have the right to clarify what information I put into the program, or request a meaningful human review of the output. It triggers more consumer rights for that individual.
Okay, understood. And so I've got these disclosures that I'm providing to my clients. How long do I have to keep these disclosures?
Yeah, so the third obligation here, in addition to initial generic disclosure, personally tailored adverse outcome disclosure, the third kind of rung here is record keeping requirements. And anyone using Covered ADMT has to keep record of the technology they're using, the authorized use for that technology in their business, as well as particular uses of it in transactions, including when those adverse outcomes came to be. And that record, per the law, must run for at least 3 years. After 3 years, the obligation to keep those records, as it's written now, goes away.
Understood. Well, thank you, Zach. That sounds pretty complicated, but I appreciate you walking us through that. I know for a fact that we're going to be talking to you in the future about some of the additional complexities under the new law. So thanks for tuning in, and thanks for explaining it to us.
Exactly. And one parting comment here, so people don't leave their computer in a frenzy. This law is signed into law today, early June 2026, but will not become effective until January 1, 2027. That's when these obligations of disclosure and record keeping will begin. Until then, this kind of 6-month period, the legislature has tasked the Attorney General with developing rules for how to enforce and interpret the law. So more to come on the finer points of how this will play out in real life.
Excellent. Thank you for that clarification. We'll see you next time.